Welcome everybody. My name is Andrea Carlise. I am a director on the Queen's Bench Bar Association Board of Directors, and I'm also the executive director of the International Action Network for Gender Equity and Law, or iAngel. And iAngel is also a co-sponsor of this event. So we're so glad to see you all here for this MCLE presentation of the next era of the fight for reproductive justice. I am going to just do some basic housekeeping at the beginning here before we introduce our panelists. And I'd also like to start out by thanking the committee that helped organize this event. That's been working very hard, and the committee members included myself and Sharon Alkire, who is the chair of Queen's Bench's Diversity Committee, and Corinne Cargo and Beth Hodes, who are co-chairs of the Queen's Bench Reproductive Rights and Legislative Committee. And they all worked very hard to put this event together and invite the panelists, and we're really excited to be hearing from these experts tonight. So as far as housekeeping goes, as you can see, we're in a Zoom meeting format. So I have pinned all the panelists. If you put your screen in speaker view, you should be able to just see the panelists. And also, if you all could keep yourselves muted throughout the presentation, that would be really helpful. I can go in and mute you if I hear you, but it would be better if you just stay muted the whole time. We will have 15 minutes at the end of the presentation for questions. And if you put questions in the chat as they come up in your mind throughout the course of the presentation, then I will ask the panelists those questions at the end. And if we have time, you can also unmute yourself in that last 15 minutes after we ask the questions in the chat. Also, for those of you who are seeking MCLE credit, we will be giving you a code that you'll need to keep to enter into the survey that you're going to have to fill out to get your MCLE certificate. So I'll be breaking in after the first half of the panel presentation to give you all the code orally, and it'll also be in the chat. And we also will have the SurveyMonkey link is in the chat already. And there's also resource materials that there's a link to that's in the chat right now as well. And you'll also get the SurveyMonkey link in an email after tonight. So there'll be lots of ways for you to ensure that you get MCLE credit. You just need to fill out the survey and put in the code that I'll be giving you in the middle of the event. So that is it for the housekeeping. And now it's my pleasure to introduce Corinne Cargo, who's one of the co-chairs, as I said, of the Queen's Bench Reproductive Rights and Legislative Committee. And she is going to be introducing our panelists and moderating the panel. So take it away, Corinne.
Okay. Good evening, everyone. We have 4 speakers to encourage and enlighten us on the next steps following the devastating Dobbs decision that the U.S. Supreme Court handed down in June 2022. We're glad to report that California has been steadfast in its support of women's reproductive rights, both with the draft constitutional amendment on the upcoming ballot and legislation that includes protections for women who wish to receive services and their care providers. This even includes women from out of state who come here seeking assistance. This also includes financial aspects for care and education, which we will hear later are very important. We're delighted to have 4 speakers this evening for this MCLE. First, we have Professor Courtney Joslin, the Martin Luther King Professor of Law from UC Davis School of Law, who is an expert in the areas of family and relationship recognition with a particular focus on same-sex and unmarried couples. She helped draft the Uniform Parentage Act, a statutory scheme for determining children's legal parentage, and in some cases, allowing children to have 3 parents. Second, we have Ann Daniels, who is a reproductive rights activist with a wide background in legal and political advocacy. As a Northern California director of what is now called NARAL, Pro-Choice California, she coordinated political, legal, tactical, and electoral strategy. She authored white papers and analyses of barriers to access in California, created the Women of Color Organizing Project, and developed the first ever interactive women's rights website focusing on abortion and reproductive rights access. From 1986 to 1995, Ms. Daniels practiced law in San Francisco and devoted an amazing amount of time doing pro bono work for reproductive rights issues for Planned Parenthood, the ACLU, and NARAL. Since 2017, she's been active with Indivisible East Bay, for which she serves on the governance committee and writes a monthly activism newsletter and other articles. Third, we have Dr. Akila Weber, California Assembly member from the 79th District. And she co-authored Assembly Bill 2134, the California Abortion and Reproductive Care Equity Act, Reproductive Equity Act, which we call the CARE Act. This established the Reproductive Health Equity Program, which will provide grants to providers who offer reproductive and sexual health care free of cost to patients with low incomes and who lack healthcare coverage. And this will expand timely access and affordability to these services. And fourth, we have Mary McNamara, president of the Bar Association of San Francisco, BASF, and the Justice and Diversity Center. On June 1st, in cooperation with the city attorney, David Chu, BASF launched a first in the nation volunteer effort by law firms that will provide free legal services to those who are affected by the Dobbs decision. This volunteer effort is called the Legal Alliance for Reproductive Rights, or LARR, and has more than 30 member firms, including many big law firms with national footprints. The Alliance will assist those who are criminally or civilly prosecuted in the post-Roe reality. BASF is planning a summit of participating Alliance members and stakeholders to triage needs. In addition, BASF is planning roundtable discussions to discuss the myriad legal issues and businesses will face as they seek to protect their employees. We have 4 areas of discussion this evening, which are number 1, Dobbs and federal actions with Professor Joslin. Number 2, the new reality with Ann Daniels. Topic number 3, California legislation supporting and expanding abortion access and state constitutional amendment, Assemblyperson Dr. Weber. And number 4, opportunities for attorneys to participate in defending access to reproductive health care and protecting those in need of legal assistance with Mary McNamara from BASF. We look forward to an informative and moving program as we learn about how we can have an impact on protecting women's reproductive rights. We reserved 15 minutes at the end, as Andrea mentioned, for questions. And we ask that you reserve your questions, but feel free to add them to the chat throughout the program at any time. So we'd like to start with Professor Joslin. So Professor Joslin, we've heard a lot about the Dobbs decision. Can you please quickly remind us what the case was about and what the court held in that matter?
Excellent, excellent. Well, and first, thanks so much for having me here this evening. I'm really thrilled to be here with all of you. And I want to step back and just sort of very quickly set the stage here. So as we all know, in 1973 in Roe versus Wade, the Supreme Court declared that the right to terminate a pregnancy is a liberty interest protected by the Due Process Clause. And then just about 20 years later, in 1992, the court was asked to reconsider Roe in a case called Planned Parenthood versus Casey. And while the court in Casey cut back on Roe in some important ways, it reaffirmed Roe's core holding that abortion is a protected liberty interest and that viability was the key line. To state it another way, Casey reaffirmed that prior to fetal viability, which is at about 23 to 24 weeks, no state could ban abortions. So the Dobbs case involved a constitutional challenge to a Mississippi law banning most abortions after 15 weeks of pregnancy. And the law was clearly unconstitutional under Casey, as it marked an almost complete ban on abortions well before fetal viability. And for that reason, both the district court and the Court of Appeal held the statute to be unconstitutional. Supreme Court, of course, accepted review. And as I think we all know, the court disagreed with the lower courts and upheld that pre-viability abortion ban. I think most people who had been watching the case closely were not surprised by the upholding the statute. I think some, though, were surprised at how far the court went to reach that conclusion, surprised that the court went ahead and definitively overruled both Roe and Casey, right? To quote from the opinion, "We hold that Roe and Casey must be overruled." And even among those who thought that that result was likely, I think some people were still also surprised at how maximalist and strident the language of the opinion is, right? It does not hold back. It doesn't just overrule Roe, it really mocks it. So Roe, Justice Alito wrote, this is a quote, was egregiously wrong from the start. In the opinion, he explained that abortion is not a liberty interest protected under the Due Process Clause. This is the case, he wrote, because abortion is not enumerated in the Constitution. And he continued, where this is true, where something is not expressly enumerated in the Constitution, it is protected under the Due Process Clause only if it was a deeply rooted right at the time of the ratification of the 14th Amendment, that is in 1868. And I know Anne will talk more about this later, but in this ground-shattering opinion, Justice Alito, writing for the court, nonetheless assured readers that the fallout would stop there. Nothing in the opinion, he wrote, should be understood to cast doubt on precedents that do not concern abortion. To be clear, the joint dissent in Dobbs did not buy that assurance. It seems impossible, they wrote, to cabin the majority's reasoning and its approach. To use their words, the words of the joint dissent, the majority's assurance that its decision would not affect associated substantive due process rights like marriage for same-sex couples, or the right to non-marital sexual intimacy, or the right to access contraception is like, and this is a quote, like telling someone the Jenga tower simply will not collapse when they pull out the bottom stick. But in any event, with regard to abortion specifically, the court claimed that it was just returning the issue to the states. But it's good, I think, to be clear about what this means. By holding that abortion is not a protected liberty interest, any laws regulating or restricting access to abortion care are now, at least for federal constitutional law purposes, subjected to only minimal, extremely deferential, rational basis review. And this likely means, and it certainly is understood to mean by the states, that any and all restrictions, including complete bans on abortion, likely are constitutional, at least in most circumstances.
Professor Joslin, can you also tell us what actions the Biden administration has taken to protect access to abortion care?
Yeah, great. So as I said, and again, as I think Anne will talk more about later, many states have been very quick to exercise their newfound power. According to the Guttmacher Institute, there are, I think, 28 states with abortion restrictions that are described either as restrictive, very restrictive, or the most restrictive. And many of these statutes have been enacted in recent months in the wake of Dobbs. These restrictive abortion laws cover a large portion of the population, obviously, and really importantly, they tend to be clustered geographically. And so as a result, a person might be many states and hundreds of miles away from a state that provides meaningful access to abortion care. And while there's a limit to the things the executive branch can do, at least without additional congressional action, the Biden administration and a number of various executive agencies have taken a number of steps in the wake of Dobbs to provide at least some guidance and in some limited circumstances to affirm or establish in the first instance some access to abortion care. So, for example, one federal agency that has taken some steps in the wake of Dobbs is the U.S. Department of Veterans Affairs, or the VA.
Mm-hmm.
So the VA has clarified that it is able to provide abortion care to veterans and in some cases to VA beneficiaries, again, in some limited cases. So specifically, they can provide abortion care to veterans and VA beneficiaries when continuing the pregnancy would put the life or health of the pregnant person at risk, or where the pregnancy is a result of rape or incest. And they can also provide abortion counseling in those circumstances. Another federal agency that has taken some steps to protect access to abortion care is the Department of Health and Human Services, or HHS. And these actions actually are in response to an executive order directing them to report back to the president on their actions on these issues. And among the things that HHS has done include providing guidance clarifying that a federal statute, the Emergency Medical Treatment and Active Labor Act, or EMTALA, requires providers at covered hospitals to provide abortion care to pregnant patients who come into an emergency room when their life or health is in danger. HHS also provided guidance to pharmacies, clarifying when and under what circumstances federal law protects people's medical information when they're seeking abortion care. And they've also provided guidance reaffirming that the Affordable Care Act, or the ACA, requires group health plans and health insurance insurers to provide contraception care. And then finally, another agency that's been active on these issues is the Department of Justice. So I just mentioned that there's a federal statute, EMTALA, that requires doctors treating emergency room patients to provide necessary stabilizing medical care. And in August of this year, the Department of Justice filed a lawsuit challenging an Idaho abortion ban that was set to go into effect later that month. The law bans almost all abortions, and DOJ argued that the law, at least in some of its applications, was preempted by EMTALA. Later that month, the federal district court did agree with them and issued a preliminary injunction blocking the enforcement of that Idaho law to the extent that it conflicted with EMTALA. But here on this EMTALA issue, there's mixed guidance that we're getting so far from courts. There was a different federal district court, this time out of Texas, that issued a preliminary injunction enjoining the federal guidance from HHS on the application of EMTALA to pregnant patients in need of emergency stabilizing care. And there, the court held that the guidance was unauthorized. So certainly, I think more to come on these EMTALA issues and those situations where the lives and health of pregnant people are at risk and they're seeking that kind of emergency care.
Okay. And then the next question we have are kind of dual questions, which is there are bills that have been introduced in Congress, including the Women's Health Protection Act of 2021 and the Women's Health Protection Act of 2022. Can you tell us what those bills would do if they were enacted, and do you think there is a chance they will be enacted?
Oh, yeah. Okay, so yeah, there have been a number of versions of this bill, the Women's Health Protection Act, and really these bills essentially seek to ensure access to abortion care for people across the country to respond to these state restrictive abortion laws that are being passed. And really at their core, what they do is they seek to prohibit a range of different kinds of restrictions on abortion care. And the legislation also expressly provides that it's intended to, if enacted, to preempt or trump inconsistent state law. So as I said, the bills seek to ban a variety of different kinds of common abortion restrictions that we've seen. And restrictions that are banned under the legislation would include things like laws that require medically unnecessary procedures or medically unnecessary in-person visits in order to access abortion care, laws that require abortion care providers to provide medically inaccurate information, laws that prevent the provision of medication abortion, and laws that require abortion care prior, that ban abortion care prior to viability. In terms of its likelihood of passage, so, a version of the bill passed the House in 2021. Another version was very narrowly defeated in the Senate in the spring, although it's maybe not quite as narrow as it first seems. The vote was 49 to 51. But of course, because of the filibuster rule, they would actually need 60 votes to pass the bill in the Senate. And I don't think at the moment there's any possibility of getting 60 votes in the Senate. I will note that in recent weeks, President Biden has pledged that if the Democrats were to gain 2 additional seats in the Senate, the first bill he would sign would be the Women's Health Protection Act. And there he's envisioning with those 2 additional seats in the Senate that the Democrats would have the votes they need to abolish the filibuster, and then that they would be able to pass it just on a majority vote in the Senate. So I guess we'll have to wait to see what happens in the election.
And then our final question is, assuming these bills were enacted, if there were a challenge to them, do you think the court would agree that Congress has the authority to regulate abortion in this way?
Yeah, great. So one of Congress's powers, and certainly an important power, is its power to regulate commerce among the states, the several states under its Commerce Clause authority. And given the text of the clause and the existing precedent, it seems, at least to my mind, very clear that Congress has the authority to regulate this commercial transaction of providing and then receiving this form of medical care for fee. Again, we're talking about a pretty quintessential commercial or economic activity, the provision of medical services for a fee and the purchasing of medical services for a fee. And this is a commercial transaction that in the aggregate certainly has a substantial effect on interstate commerce. So again, to the extent that the law is regulating this commercial transaction, at least under current law, it seems quite clear that it's within the core of Congress's Commerce Clause authority. I mean, there's some iterations, or you can imagine a law that maybe just declared that Roe was the law of the land. Maybe that kind of declaration would be more questionable. But again, the actual regulation of the provision of this commercial service seems quite central to Congress's Commerce Clause authority. I will note, to be clear, the court has clarified that Congress's power under the Commerce Clause includes the power to eliminate a market altogether. Court held that in Gonzalez versus Rake. And so for reasons that are similar to the ones I just outlined, I also think that one could make a persuasive argument that Congress would also have the authority to pass a statute banning or limiting this commercial activity. And of course, there has already been a federal ban that has been introduced. Lindsey Graham introduced a bill in the Senate that would ban abortion at 15 weeks. And depending on the outcome of the election, we might see other bills introduced.
Well, thank you very much. I have a few questions I'll put in the chat to save for the end. And now we're ready to talk about the new reality with Ann Daniels. So our first question for you, Ann, is, and I think you wanted to have a share screen with the Guttmacher Institute map.
Yeah, Andrea, if you could put that up, the Guttmacher graphic.
Okay, so while she's doing that, I'll start. The Dobbs decision explicitly left abortion regulation to the states. What has happened since then, and how do abortion regulations in the states look now?
So that's how abortion regulation in states look now. So first of all, thank you for having me here to talk about this not so cheery talk, although there will be some good news. We call this the patchwork quilt. It's a term that's been around for a very long time, and you can see why. It's kind of a mess. So in this chart, they categorize things from most restrictive to most protective. There are 13 states, according to the Guttmacher Institute. And for those of you who don't know the Guttmacher Institute, it is a part of Planned Parenthood, very, very highly respected for their research. In 13 states, abortion is completely banned with very limited exceptions. That can include a ban on abortion from the moment of conception or fertilization, or a definition of pregnancy as beginning at the moment of conception or fertilization. It's kind of unclear. I did a bit of a deep dive on that, but there are definitely 4 states that have that kind of a ban, and a possibility of another 8. So possibly 12 states where either pregnancy is defined as beginning at fertilization, or abortion is banned beginning at fertilization. In other states, it's banned after a certain number of weeks, which can range from 6 to 24. Just as a side note, I was talking literally yesterday with a friend who's in her 30s who has irregular periods. Her contraception failed. She didn't realize that she was pregnant until she was nearly 20 weeks. So yes, that kind of thing really does happen. In some states, the state constitution explicitly excludes abortion rights. Typical restrictions can include patients being forced to make 2 trips, one for counseling and another 24 hours, 48 hours, 72 hours later for the actual procedure. State Medicaid coverage can be banned. Private insurance coverage is banned in at least 2 states. Medication abortion may be required to be provided in person, because some states ban the use of telehealth or mailing pills, or may require an in-person visit. Some states require that only physicians can provide abortions and not other qualified healthcare professionals. Parental consent required in many, many states, not in California. And then we have unnecessary regulations for clinics, such as requiring a number of doctors to be present at all times, requiring clinics to be basically set up as hospitals, things that are basically there just in order to make it impossible for clinics to operate. And then you have the atypical regulations, like Texas's famous bounty bill, where they're trying to get creative. And more states, I think, are going to be following that. The good news along the lines here is that we have states like California, which Assemblymember Weber is going to be talking about, and California and Oregon and Washington have kind of joined together in a Western States collective to help women from other states. Kansas, of course, defeated the ballot proposal to remove abortion rights from the state constitution. Michigan and Vermont have upcoming votes on pro-choice ballot initiatives or referenda. Kentucky's got an anti-choice one on the ballot. And then you've got states where candidates are making it an issue in their campaigns. We did have one candidate just recently state in so many words that abortion should be between a woman and her doctor and local state legislators. So it's very definitely an issue in the elections that are coming up right now.
Okay, so our second question is that the court insisted that its decision was only about abortion and no other rights would be affected. The court specifically mentioned contraception and LGBTQI rights. Have any other post-Dobbs state abortion laws in fact affected these other rights or had direct effects other than abortion, like contraceptive care or reproductive health care?
So Courtney mentioned this and the dissent's skepticism, and all I can say is if you buy that, I've got a bridge I'd be happy to sell you. Justice Thomas at least was honest and said in future cases, the court should review and overturn other rights to privacy and autonomy. And he specifically called out contraception and same-sex relationships and marriage. Turning to birth control, when I worked in reproductive rights, we all said they're coming for your birth control, and I really hate it that we were right. Why it's an issue, I mean, it's really hard to see how the court would treat contraception differently under the rationale that that Courtney was discussing, that they came up with in this. There's no mention of it in the Constitution. There's no historical foundation, etc. The only difference is their mantra that abortion destroys a potential life. But wait and see what the religious right does with that under the life begins at conception laws, because if life is beginning at conception, then you do have forms of contraception that prevent implantation, specifically IUDs, Plan B, emergency contraception. So you have this statement, which is not a medical fact. It is a statement from some legislators and from the religious right that this constitutes abortion. It does not constitute abortion. It prevents implantation, but that would definitely fall under the laws that prohibit abortion, where life is defined as beginning at fertilization or conception. And I'll note that in Burwell versus Hobby Lobby, the court allowed an employer an exemption from the ACA's contraceptive mandate on religious grounds because Hobby Lobby claimed that they believed life began at conception and that emergency contraception and IUDs violated their beliefs. So all they had to do was come out with this claim, which is contrary to scientific fact. Some states already have restrictions, like allowing healthcare providers, insurance, or pharmacies to decline to cover or provide emergency contraception or IUDs. The canary in the gold mine right now is college campuses. The University of Idaho basically stopped issuing birth control at the beginning of this school year because they said there was a, quote, unclear and untested law that had been on the books since before Roe v. Wade, and they weren't willing to risk it. Other universities have said they'll continue providing it, but students are starting to consider state laws in deciding where to go to college. How else it could affect birth control? Researchers are publishing statements saying that certain laws, like the Texas law, will affect their research into fertility work and period tracking, which is essential for contraceptive research. And of course, the Senate has blocked the bill that would have created a federal right to contraception. So anybody who says surely contraception is safe, nope.
Okay, so I think you've answered what our next question was going to be. What other rights do you see states moving to restrict as a result of Dobbs? So we've got contraception, but what do you think about assisted reproduction, healthcare, and anti-gay, anti-trans rights?
Watch out on all of them. The opinion cites the Godoldig case, which held that pregnancy is not a sex-related condition. So the opinion's
I don't understand that.
of women's health and bodily autonomy is, shall we say, stated.
Mm.
We're already seeing this decision branch into reproductive health care not related to abortion, where Catholic hospitals and in fact other hospitals are turning women away with incomplete miscarriages and ectopic pregnancies. So we're seeing deadly consequences to women's health. LGBTQI rights. To be clear, abortion rights impact the queer community directly. I mean, LGBTQI folk need access to all forms of reproductive health care, including abortion. So the court says LGBTQ rights are not affected. But in some states, this is having a direct effect. The Texas Attorney General has said that after Dobbs, he'd be willing to defend a state right criminalizing sodomy. In Alabama, the Attorney General has specifically cited Dobbs in asking a federal appeals court to lift an injunction against a law prohibiting medical treatments for trans youths. So Dobbs is definitely already making its mark there. In the 2 to 3 months before the leaked draft, the Human Rights Campaign says there were over 300 anti-trans bills in state legislature. Since the leaked draft in May, there's been legislative action just blossoming all over the country, largely focusing on gay and trans youth. So we've got the Don't Say Gay type bills. We've got bills prohibiting gender affirming care and other health care for trans kids, bills prohibiting trans kids from participating in sports, and the ever popular bathroom bills. In vitro fertilization and assisted reproduction. Well, if pregnancy begins at fertilization or conception, that is a risk. However, a note that many of the laws define pregnancy as beginning at conception, specifically define abortion as something that is done to a woman's body. So it's unclear if frozen embryos, for example, would be affected. I think we can expect to see laws that will deal with that. I also want to mention the right to travel, because at least one state has tried to institute a ban on a right for women to travel from the state that prohibits abortion to a state that allows it. I think of this as the Handmaid's Tale kind of rights, where you can't leave, it's not permitted, and you can't leave to go someplace where it is permitted. This is based on child endangerment statutes, the idea that a woman would be crossing a state line to do harm to a child, that child being the fetus. Those have not passed yet, but I think we can expect that. Fetal personhood bills, child endangerment applied to the fetus, prosecution of pregnant women, which is already going on in several states, laws in effect that give fetal rights, that give personhood rights to the fetus. And in Doe versus McKee, Rhode Island, petition for cert basically asking the court to determine whether fetuses have constitutional protections. Look for that one. And one that's rarely mentioned, but I want to bring up, is disability rights. It's not mentioned in the opinion, it's often forgotten, but the disability community has been subject to forced sterilization and deprivation of the right to make decisions about reproduction and bodily determination in so many ways. A lack of health care that respects the rights of the disabled to self-determination. And I can try to put the link in later, but the Disability Rights and Education and Defense Fund has issued a stunning statement after the Dobbs decision, basically saying abortion rights are disability rights, and just showing how all these rights are linked together.
Well, thank you very much. But I will we do have one last question, but we're out of almost out of time. Is there an overarching pattern to what the states are doing in these areas?
The pattern that I see is an attempt to turn us against each other by creating a class of the virtuous citizens who are going to turn on the evil people against us. So in Texas, you've got the people who are going to turn in the people getting abortions or the ones who are helping them, the bounty laws. You've got the parents with trans kids who are labeled as child abusers. And to me, it boils down to a creation of this class of virtuous citizens who are going to turn against the rest of us. Even women who aren't seeking abortions get swept into the morality police net. And I think we just need to acknowledge that this is a threat with many more threads than at first meet the eye. All our rights are connected. And this is a time to really look around and make common cause with everybody else getting swept up into this web, because I'm fond of saying, united we stand because we had better.
So luckily, we have some hopeful news in California, and Dr. Weber will be able to share some of the strides we've made in the state of California.
Before we get to that, Karine, I just want to jump in and give, because Kamiko gave me this job to give the code for MCLE credit that people will have to put into the SurveyMonkey. It is 10 QB 2022, 10 QB 2022, and it'll be in the chat as well. I think Kamiko's putting it in there. So sorry to interrupt, and really interesting, Professor Jocelyn, and I really appreciate it. Okay,
and we are planning a program in late January, and one of the speakers will be addressing assisted reproduction and the impact of the decision on that. So that'll be another continuation of what you started to address, Anne. So Dr. Weber, our first question for you is, how has your background as your background as a medical doctor enhanced your ability to advocate for legislation protecting women's rights to access reproductive care?
Well, first of all, thank you so very much for inviting me to speak. I do have a very unique background in the legislature. I am one of now 3 physicians, if you count both the Assembly and the Senate. However, I am an OBGYN. And so I have dedicated my professional career to ensuring access and affordable and excellent reproductive health care for our women and girls. And so it's not only that I'm a physician, but one who has practiced within the realm of women's health care for many, many, many years. And so when I approach this, I like to remind people that my legislator friends, many of who are lawyers, that we're talking about real people and real lives. And even as I'm listening to the discussion here and all of the different cases and what it means and what it doesn't mean, I think back to the fact that every time I'd be on call, you'd have someone come in with a miscarriage or an ectopic pregnancy. It would not be uncommon to have someone with an unintended pregnancy show up questioning. Every day, hundreds of women across this country find out that they're pregnant. Most of them is after 6 weeks, even if they do have regular periods. And so when we're discussing these different laws and who should have what and who should not, these are real women's lives and girls' lives that we're dealing with. And right now with this decision, we've put so much in limbo for their lives, for my fellow colleagues across this nation, their careers, what they can and cannot do. Will they be sued? Will they lose their license? I remind people that I have counseled many girls and many women who have found themselves in a situation with an unintended pregnancy. And, for those who choose to terminate their pregnancy, it is never an easy decision. It is never something that someone just wakes up one morning and says, I'm just going to go do this. There are so many factors that are taken into account when they make that very, very, very challenging decision, even if they choose to continue with the pregnancy, because at the end of the day, whether they choose to continue with the pregnancy and keep the baby, continue with the pregnancy and put the child up for adoption, or terminate the pregnancy, it is a decision that they will have to live with for the rest of their lives. And it is their lives. And so I remind people that the decisions that go into this are a variety of things. It could be health related. It could be non-health related. It could be different situations within the family dynamics or financial, or someone's just not in the right physical or mental space at that point. But it is their life and it is their body and it is their decision. And so, you know, as all of these discussions go on, I always like to remind people that we are talking about someone's life and their body and the ability for them, for a competent individual, to make a decision over their body. And I also remind people that this ruling, unfortunately, is so widespread. It's not just about abortion. You know, one of the things that happened right after the decision came down. So I practiced in a lot of different states. I've trained in a lot of different states. I did my fellowship in Ohio, and I then went to Texas, and I practiced in Dallas, Texas, at the hospital that, you know, gives the most amount of births in the country in Dallas. And I left because I said, this state has a war against women's health. And I was right. You know, right after the decision came down, since I had practiced in Ohio before and had been licensed there, I got some correspondence from one of the people in the medical societies there. And it basically stated, if you're on call this weekend and you have someone who comes in with an ectopic pregnancy, before you treat her, you need to contact the hospital's lawyer. And that hit me so hard, because that goes against everything that we've been trained to do. We know that an ectopic pregnancy, which is a pregnancy outside of the uterus, is not viable. We know that if we can get to it early, treating it medically is the best thing. But what has happened through this decision and the vagueness of it is that people don't have access to medications for ectopic pregnancies, which puts them in a situation where they have to undergo a surgery at some point. And because doctors don't want to be sued for intervening too soon, then the question is, what is too soon and what is not soon enough? So we got to get to the patient, not when they're stable, but right before they completely crash, right before the belly is completely full of blood. So maybe half full of blood, maybe the pulse is going up a little bit, maybe the respiratory rate. I mean, this is so counter to the way in which we train. This is so different than how we practiced even a year ago in even the reddest of states. So it's not just about someone who has a perfectly normal pregnancy and desires to terminate for whatever reason. It's so far reaching. Someone, you know, one of the questions before is, will birth control be impacted? Yes, it will, because it's limiting access. You know, when I was in Texas, like I said, they had a war against women's health. Planned Parenthood facilities were being shut down left and right. So I would look up and I would have these young girls in my clinic to get their Nexplanon removed. And I'm like, well, where did you get it? And why didn't you go back to that clinic? Well, that clinic is no longer open. So that access is no longer there. So they don't even have the ability to go to places in their community to prevent an unintended pregnancy. You know, one of the other things is when I was in Texas, which I thought was crazy, because like I said, I was at UT Southwestern that had the largest, still does, the largest OBGYN program there. We train more residents out of that program than any other program in the country. And they would not allow their residents to learn how to do abortions. They had worked out a deal with the county that the residents wouldn't be trained. And I was like, oh my God. But think about that now in all of these states. You just saw the map, you saw the different colors. All of these states have programs where they're training our future reproductive health providers, and they're not being trained in this anymore. So what does our future look like for our providers of women's reproductive health care. And so it has such far-reaching implications. And you know, one of the things I always remind my colleagues in the legislature is that reproductive health care and having access to reproductive health care is healthcare, is providing good health care. And if we want to make sure that we are providing equal access and equality in our healthcare system, then we have to make sure that we are providing reproductive health care, and that includes contraceptive services and abortion services.
Wow, that's really powerful. If I could just make one comment on a personal note, my mother was a surgical nurse from the early 60s until 2018. And she said one of the most traumatic things she's experienced in all those years in the operating room was a young woman who was hemorrhaging from an illegal abortion in a suburb of Chicago, where the father of the baby was a married man. And she just is emphatic about this. So anyway.
Well, definitely that's exactly what's happening now. I'm hearing stories of my colleagues in some of these states where they are doing hysterectomies on women in their 20s because the abortion, the botched, backyard abortion went wrong. The person ended up with an infection, became septic, and they had to have their uterus removed. So, the horror stories that we heard, that I heard about, from the pre-Roe versus Wade days are now a reality today.
Yeah, that's scary. So we have a lot of legislation in California, and I'll give you an opportunity to hit some of those highlights, but I think because you authored the CARE Act, we'd like to start with that. And can you give us an overview of the provisions?
Yeah. So this session, I authored AB 2134, the California Act. It's a reproductive access measure that was sponsored by Planned Parenthood and National Health Law Program, along with many others. And basically, it provides grant funding to California safety net providers. So essentially, for people who are providing these abortion and reproductive healthcare services to people who either don't have insurance or their insurance won't cover it, this is to ensure that our providers here in California will be able to be reimbursed for their services. A lot of times when I was going through the hearing, some of the Republican colleagues would love to say, oh, so now we're funding for people outside. That's not what this particular bill did. This makes sure that our providers here in California get reimbursed for their services. Like anybody wants to be reimbursed for their services. So starting in 2023, Medi-Cal providers will be authorized to apply for these grants for a 12-month period if they provide free or reduced cost abortion and contraceptive services to individuals below the 400% poverty line. It also requires the Department of Industrial Relations to post on its website information regarding abortion and contraceptive benefits that may be available at no cost through this program to employees whose employer-sponsored health coverage does not include coverage for both abortion and contraception. I'm very happy that Governor Gavin Newsom signed it into law, and I'm even more ecstatic that there's actually $40 million that was allocated in our budget for it. So we have the funds, and now we have it actually in law that this will be the case. So our providers will be able to be reimbursed. So cost won't be an issue for patients, and it won't be an issue for providers who are providing these services.
So you touched on a few other kind of umbrellas of concern, and maybe I can break it into kind of subtopics. One was criminal and civil liability. I understand there's two bills that were passed and signed into law this year, protecting providers and recipients of services from liability, both criminal and civil. And so do you want to talk about that a little bit?
Yeah, so one of the good things is there was a council, and you all may have heard about it. It's called the FAB Council, the Future of Abortion Council, that convened last year. And what they did was they recognized the fact that there was very high likelihood that Roe v. Wade would be overturned. And what is it that we could do here in California to help ensure that our residents were able to have access to abortion services. And if people outside of California needed to come, what is it that we needed to do in our state to prepare for that? And so they provided a list of things that should be done. And in the legislature, specifically within the Women's Caucus, some of us took a look at those and created legislation. We came up with a very robust bill package of about 15 bills. 13 or 14 of those actually got signed. So we were very, very pleased about those. And a couple of those, like you mentioned, AB 2142 prohibits law enforcement from cooperating with out-of-state entities to knowingly arrest someone who comes to California for an abortion service, so they don't have to worry about our law enforcement picking them up and then, releasing them to the law enforcement in their state. AB 1666 protects patients and providers in California from civil action and financial retaliation for providing abortion care from a state that has deemed it illegal. AB 2191 protects the medical privacy of patients, which is extremely important. So we as physicians do not have to disclose this information if someone had an abortion to an outside or out-of-state entity that is trying to gain access to these things. We also passed AB 2233, and this was initially a very controversial one, but the crux of this is to prevent someone who has a pregnancy loss from being prosecuted. Because what has happened in some states or some areas here in California is if you have a woman who goes in, let's say she was on drugs, cocaine, had an abortion, and baby dies at 2 weeks. This law prevents someone from coming and suing that particular patient. And we have a lot of other ones. It protects our license as well. Medical providers, 26 prevents, our license from being revoked or suspended because we provided some kind of abortion service to someone from out of state. And one of the very important ones is SB 1142. And that created a one-stop shop internet website under Cal HHS. And the reason why I say this is most important is because when I speak with my OBGYN colleagues across the country, especially in those states that have enacted these very restrictive laws, they didn't know where to send their patients or who to call, or, to say, you can go to California, but where in California? And there are some, unfortunately, clinics here that kind of advertise as someone that may provide abortion services. And then when you get there, you realize that they don't. And their whole purpose is to try to persuade individuals to not get abortions. So this internet site is extremely critical for providers outside of the state to go to, for patients outside of the state to go to, even within the state, so that you know where you can go to get the best evidence-based, true reproductive health care. And so that the passage of that one and the website is actually up at this point for people to be able to go to.
So I also saw that there were a few items about training and expediting licensing for out-of-state providers. So I thought that was also fantastic. But our final question is, can you provide your thoughts on the importance of the proposed constitutional amendment?
So, I think that for people who felt that Roe would never be overturned, I think we all realize that you can never say never when it comes to just based from the Supreme Court, or even just a law from the Assembly, because someone can come in and change that. But when you actually put something within the Constitution, it's a lot harder to change. And so it is extremely important that we pass Prop 1 so that we enshrine this ability within California for a woman to be able to have autonomy over her own body and decide, if she wants to continue with a pregnancy. if it's what's best for her. And if we don't, who knows what may happen in the future? I mean, we are very lucky right now with the makeup of our legislature and our governor being so very pro-choice and pro women's reproductive rights, but that could easily change. And so this proposition is extremely important to pass. There is, a lot of chatter on the other side about the fact that, there is no discussion in it about viability. And as a physician, I am very happy that that's not in there, because that's really a discussion between the patient and their provider. Viability is not a construct that we really discuss much within the OBGYN world, because we know that changes, right? So if you have a baby that will be able to breathe once when it's born, is that truly a viable pregnancy? And so those are conversations that really need to happen between the patient and their provider. And so that area was purposely left silent to allow for that to happen, to allow for the woman to have that ability here in California. So Proposition 1 is extremely important to pass. Polls show that we will most likely get there, but it's important to make sure that people get out and vote. And that, as many people are used to just voting no on all propositions, that is, if any proposition you're going to put yes for, that is the one you put yes on.
Okay. All right. Well, thank you. We're going to probably have quite a few comments in our Q&A, but we would like to turn our attention for the next 15 minutes or so to Mary McNamara, President of the Bar Association of San Francisco, about the opportunities for attorneys to participate in defending access to reproductive health care and protecting the people in need of that assistance. So, Mary, our first question is, how can lawyers in California, specifically in the San Francisco Bay Area, provide pro bono legal assistance to support those in need of reproductive health care?
Thanks very much for having me. What an illuminating discussion. There are a couple of ways. I'll talk about the way in which the Bar Association has organized a group of lawyers presently, but there are longstanding associations, and Daniels knows this very well. NARAL is an amazing organization, Planned Parenthood, the ACLU of Northern California, Center for Reproductive Rights. There are two in particular I would advocate lawyers to join. One is an amazing and extremely well-credentialed nonprofit called If, When, How. It was part of what Dr. Weber has described as the FAB Coalition. And they have been anticipating, I think, in a very clear-eyed way for a long time, that Roe was in great danger and that we were going to be at this terrible pass in our constitutional development. And so they have an outfit called Reproductive Justice Lawyering. It's a network that people can join. You don't have to have any expertise in reproductive care. Virtually none of us does, who isn't part of Planned Parenthood or isn't an Ann Daniels. But you can go there and you can, contribute in various ways. So they will educate you through symposia, through legal education. You can take on representation matters. You can advocate for bail in criminal cases. You can also advocate for legislative change in various states. They work across the country. That one, I think, is a really feisty, up and coming, very, very good nonprofit. On the criminal side, there is the National Association of Criminal Defense Lawyers. It's a very eminent national association that has a special reproductive justice working group. They are national in reach and they are in banned states, and they're the people who probably on the ground will know what's happening in terms of criminal prosecutions and how lawyers in the states that are protecting abortion rights can contribute. You can be, a research and writing person for a public defender or a criminal defense lawyer in a banned state, for example. And likewise, they also put on education in this sphere and can, I think, distribute resources very adroitly. And then there's our organization and the Bar Association, if you want me to get into that.
Right. What does the Alliance for Reproductive Rights have planned for how it will work to protect those in need of legal assistance moving forward?
Yeah, so we on June 1, which is after the leaked opinion by Justice Alito emerged in San Francisco, called the alarm, and with the city attorney's office, Bar Association of San Francisco put out a call to action to the legal community here, asking for law firms to come forward and join our new alliance, which we call the Legal Alliance for Reproductive Rights. And on that June 1 day, while we still had a constitutional right to abortion, 20 law firms came out and joined us on the steps of City Hall just to prepare for what we thought was coming. At the end of June, of course, we got the actual decision. And then that day we got flooded with calls, and we quickly went to 30, 40, 50. We're now 70 law firms and counting. And our membership is law firms. We have a huge diversity of firms, a lot of national footprint firms. So these firms have offices, some of them in banned states like Texas, for example, but they can quickly marshal resources to jump in pro bono in those states at those times when they're at the tip of the spear. Others, like my firm, I have a boutique firm that has a specialization in criminal defense. We can offer our services pro bono to public defenders and to criminal defense lawyers in banned states who are defending cases. I just want to speak a little bit about the sorts of cases that we anticipate seeing. So far, I'm not aware, and perhaps the other experts in the panel know this, but I'm not aware of any state that has criminalized the woman, the pregnant person herself, from having abortions. That's coming, I'm sure. But so far, I don't think any such law has passed. What's going to happen, I think, is the sort of thing that happened in California in a case that I had with the National Advocates for Pregnant Women, the ACLU of Northern California, If, When, How. And that is, I think, folks who were in the category described by Ann Daniels as the people who are accused of child endangerment, or the people who, as Dr. Weber was talking about, the women who are seen to be doing something reckless or negligent during their pregnancy, like taking drugs. And those cases, unfortunately, are, I think, going to be the ones that are particularly going to be prosecuted. There were 2 in California. And as I said, I worked on one of them, which actually led to a change in the law described by Dr. Weber, AB 2223, spearheaded by Assemblywoman Buffy Wicks, which directly took aim at these prosecutions to say that in California, no longer could a woman be prosecuted for her pregnancy outcome, no matter what caused the stillbirth or the miscarriage. But other states, I think, are going to go absolutely crazy on those kinds of cases, because I think the Dobbs decision has done more than obliterate a constitutional right. It seems to have given the permission structure to very reactionary elements in this country to go after those who are deemed to be bad people. And I think poor women, particularly poor women of color, are going to fall into that category and are going to be prosecuted. So these are the kinds of cases we think are going to come. And for that reason, we've been beefing up our membership to address them with having a very broad, diverse range of experience. We don't expect we're going to be needed much in California, unless that is, a doctors, heroic doctors, put their licenses or their liberty on the line by, say, doing telemedicine that might reach into banned states. Those folks are going to need protection against prosecution from out of state.
And can Bay Area lawyers who are not working for law firms join the LARR, the Alliance?
So we tend to focus on law firms just because we know more about law firms than we do about particular individuals. I would refer the individuals to the two organizations that I highlighted, If, When, How, and the National Association of Criminal Defense Lawyers.
Mhm. And if and how does it work for out of state cases that you were talking about, California attorneys assisting with? Would they be admitted pro hoc vice in these other states, or are there particular bar association
yes.
rules in those other states that permit that?
Yes. So the way that we've been envisioning it is as sort of a support role, as opposed to an actual role of a California barred attorney appearing in another state. That's for the smaller firms like mine, where we are not licensed in other states. But for the national law firms, many of them have footprints in those states and have attorneys who are licensed in those states. And that's why we wanted to have law firms of that size in our membership, so that we could deploy boots on the ground directly.
Okay. And then we have a question for all panelists on this topic. We know that it's going to be a long-term battle. What are other ways we can help in the fight for reproductive justice? Anyone who wants to go first can unmute themselves from the panel.
Well, could I just say something, because I was impressed by what Dr. Weber said. I think we should be telling stories about how dangerous pregnancy is. And I think, Dr. Weber said it's not the usual, you just have a pregnancy and ho-hum, you decide you're going to blithely terminate it. Pregnancy is more dangerous than abortion, and by a long shot. And I think that's totally lost in the debate. It's extremely onerous for a woman to carry a child to term. There are all sorts of impediments, even to people who are rich and have the means. And if you are poor, and if you're struggling to put food on the table, and if you have your own kids, which most people who get abortions do, the impediments are enormous. And I think we should be out loud and proud about that. We should be evangelizing that story. And I must say, I've had it up to here with people who are telling women what to do. That's one thing I would say.
I could not agree with you more. I did my residency, my OBGYN residency at Cook County Hospital in Chicago. And all we saw were just high-risk pregnancies. And I, at that point, said, I'm never going to have any kids, because this is the most, dangerous state you could possibly be. And you could be fine today, and then in 5 minutes, like, out. So pregnancy is an extremely dangerous condition. And I think because in the United States, for a vast majority of people, we have done a very good job in reducing maternal morbidity and mortality, we forget how dangerous pregnancy is. But one of the other things that I would also like to remind people is that what this is also doing is it's just increasing the disparity within our healthcare system. Because when you look to see who will still have access to reproductive health care and versus who won't, it's already the people who Black, you're brown, your lower socioeconomic status people who already have significant issues when we're talking about issues within the healthcare system. That's already the population that has the high risk pregnancies, because they have the obesity and the diabetes and the high blood pressure and, the inability to access, the best doctors right around the corner from their homes. And so what you have done is just widen that inequity gap. And, we talk a lot about the increased risk of Black women maternal morbidity and mortality. And we're going to see that worsening as well with this particular law. And so, I would just also remind people that not only is pregnancy a very dangerous state, to be quite honest with you, but we are doing such a horrible injustice to the overall healthcare system, because we're just widening that gap of inequality, the who has versus, those that don't have. And it's going to impact those that really need us the most.
And if I could add, rural women are also very much in the crosshairs. I mean, Courtney, you spoke about the clustering of states, but if you look at the larger states as well, Texas is a real big state. You can be in Texas and be hundreds and hundreds of miles from the nearest state. You can be in California And your closest state can be a state where abortion is illegal. And it can be very hard to find a provider, which is why the kind of legislation that Dr. Weber has been talking about is so important, because it's about access. It's not just about legality. It's about access to safe, legal abortion where you live. Because if you're east of the Sierras in some rural town, you may not be close to a California provider. And there are organizations, Access Reproductive Justice is one, that help women get to the services that they need. So I do encourage people to look for those organizations and to support those organizations, not just that provide abortions, although those are incredibly important, but ones that help women get access. That help women travel to them, that help women find lodging where they need them, because that can also be very expensive.
So I think we may have some questions in the chat.
Yeah. So this first question is for Professor Jocelyn. Is the federal rule for abortion care restricted as to what practitioners are affected? Does the facility have to receive federal funds?
Are you sorry about EMTALA? I'm not quite sure what the question.
Yeah. Yes.
Yeah. Yeah. So it applies to hospitals that are receiving federal funds, and it's specifically requiring care for patients that are coming into the emergency room who need to be stabilized. And at least the Department of Justice's position and HHS's position is that that includes the provision of abortion care where that is necessary in order to stabilize the patient's care.
Interesting.
This next question is to Professor Jocelyn as well, but anybody could answer. And there are actually two related questions. So the first is just kind of a statement. So I'm going to read it because it's kind of a preface to the question that Corrine asked later. So Beth Hoda says, though it is common knowledge that Justice Ginsburg supported a woman's right to choose abortion, a lesser known critique of hers was that she considered Roe to be a physician-centered decision rather than woman-centered. Further, Justice Ginsburg held that Roe's focus on restricting access to abortion violated a woman's privacy was the wrong argument. What she hoped for instead was a protection of the right to abortion on the basis that restricting it impeded gender equality, and, quote, believed it would have been better to approach it under the Equal Protection Clause because that would have made Roe v. Wade less vulnerable to attack. So this essentially leads to the question that Corrine asked, which is, why does abortion rights legal precedent not address equal protection rights?
Yeah, so it's a great question. So you're right that Justice Ginsburg, as well as many other scholars and lawyers, have argued over the years that the abortion right would have been better protected under the Equal Protection Clause, under a sex discrimination theory, as opposed to privacy interest protection under the Due Process Clause. Some people, I think, find it just more persuasive and feel like it gets more directly to the real core of the issue, which is that women, for the most part, are the people who are being denied care, and the denial of that care has incredibly profound impacts on the course of that person's life, as Dr. Weber was talking about. It impacts her financial stability over the course of her life. It affects job choices that she makes over the course of her life. It really affects all aspects of her life. I think one could argue another important benefit of arguing it under an equal protection theory is that theoretically could have required the government to actually make sure that women had access to abortion, practically speaking, right? Because it was argued under a privacy theory, the way the court understood the right was it just precluded the government from interfering in the person's ability to have access to the right. But the court rejected arguments in the past that the government had an affirmative obligation to make sure that women had meaningful access to it, even if they could not afford abortion. So certainly, I think reasons to support that view that there could have been some benefits to arguing it and having it decided under an equal protection theory. I mean, I guess I'll say, though, even if Roe had been decided under an equal protection theory, I'm not sure that that would have resulted in a different outcome in the Dobbs case. And in fact, the Dobbs decision suggests that it would have come to the same conclusion. There were some advocates who pushed a sex discrimination theory in amicus brief. So Professor Reva Siegel and Melissa Murray filed an amicus brief in which they made a sex discrimination argument. And Justice Alito, in his opinion, dismissed it very quickly in a single paragraph in the opinion, paid it no mind. And Anne mentioned this earlier, somewhat ironically, in an opinion that blithely overrules 50 years of precedent upon precedent upon precedent. He simply declares that the sex discrimination theory was precluded by precedent, citing to a single 1974 decision that I think most people view as entirely antiquated, and a decision that Congress essentially abrogated for statutory purposes 2 years after it, or 4 years after it was released. So again, I don't think that Justice Alito would have reached a different conclusion had Roe been decided under a sex discrimination theory. But again, maybe it helps us better focus on the real issue, which is the impact of the denial of this form of healthcare on the lives of women in this country, which of course is incredibly profound.
Yeah, absolutely. So the next question is to any panelists. How do you think this SCOTUS will deal with the freedom of religion question in regard to when life, as you know, the Jewish religion says life begins at birth, and many other religions don't, some religions obviously say it begins at conception. So what do you think SCOTUS is going to do with that if it gets to SCOTUS?
I think to a certain extent it already has in the Burwell case, where they allowed a company to decide for itself that life begins at conception. Now, you have questions of corporate personhood in there, and that's different from a state legislature declaring that life begins at conception. But I think that is a door that has been opened that this particular Supreme Court will gladly walk through. I don't think they really care what Judaism declares in terms of when life begins, nor I think do they think that Judaism requires abortion as necessary health care when, for example, a pregnant person's life is in danger or health is in danger. I think they could care less about that.
I mean, I'll just add, and maybe this question was prompted by this, there is a lawsuit that's pending in Florida that's filed by a Jewish congregation challenging Florida's abortion bans abortion at 15 weeks. And, consistent with the question, they take the position that the abortion ban law interferes with their practice of their religion, which teaches that abortion is necessary in some cases. And so they're presenting an argument that it's interfering with their practice of their religion. That is an argument that the court has been quite protective of in recent cases in other contexts. Arguments that, for example, COVID restrictions interfered with places of worship ability to practice their religion, or the recent Kennedy versus Bremerton case, the praying coach case that the court just decided. But I think consistent with Anne's suggestion, I'm not convinced that the court is going to be as protective of this congregation's claim that it's interfering with their practice of their religion as the court has been in some other contexts in recent years.
Yeah, so much for intellectual integrity by SCOTUS. So the next question is, companies like Amazon have vowed to reimburse employees who travel to receive abortions. Would this not introduce a new set of concerns about employee privacy and possible retribution from employers? Anybody want to take that?
I mean, so it's, of course, so if one were seeking to receive compensation, for example, from one's employer in order to receive abortion care in another jurisdiction, it would require one to disclose information about their need for abortion care that they might not otherwise be providing to their employer. And so it, like many other issues, touching on what we're talking about today, raises important privacy concerns. I'll also note, I mean, there have been questions too about whether or not these companies, in providing funds to allow a person to travel from a state that bans abortion to a state that permits abortion, whether they could be potentially liable under a, for example, sort of a Texas-like bounty type statute. And so I think there are also a lot of important and interesting legal questions that need to be considered as employers are seeking to provide assistance to their employees who need this care, as well as for people who live in states with restrictive abortion laws that are seeking to access care in other jurisdictions.
Well, I think that kind of answers the very last question that's in the chat, which is dozens of companies have committed to helping their employees get access to abortion. Could an employer or plan administrator have exposure to civil litigation or criminal violations in states prohibiting or severely restricting abortions?
I do think it's interesting that some extremely large and powerful companies have led the way on this. Amazon certainly has no lack of funds to defend itself should it be brought to court. I do think that there's always a danger when, when private medical information is disclosed to individuals within the company, because company policy can be whatever it is, but you never know who the HR director is.
Yeah, and I would just add that I think the questioner is exactly right. There was a very disturbing letter put out in Texas by the Texas Freedom Caucus. Note to self, be very afraid when anybody describes themselves as in favor of freedom in this country. But in any event, the Texas Freedom Caucus sent a threatening letter to a law firm in Texas saying that the law firm's pledge to help its employees travel out of state to receive abortion care in other states was a felony under Texas law, even though it's not at all clear it was, and then threatening the lawyers with reporting them to the state bar and announcing a host of new bills that they were going to introduce that would make the vigilante lawsuit look tame. For example, they were suggesting that if it would be mandatory to disbar a lawyer who was part of a law firm that had such a policy, and that if the Texas State Bar did not take steps to disbar those lawyers, then your local friendly neighbor could sue the state bar to enforce the disbarment of that lawyer and introduce new felony prohibitions on travel. I think that was mentioned by Anne. So the answer is yeah, I think this is going to be a very fraught area of the law. And it, the thing we haven't really discussed this evening, but which is another direct threat to our democracy, is vigilante lawsuits, and then the protective state's response to them are going to just tear at the fabric of interstate cooperation. This is just going to happen, where in an effort to protect our own citizens in California, we may end up not honoring certain subpoenas or warrants from a banned state, and they're going to do the same to us. And it's going to bleed into all sorts of areas, like trans rights, all sorts of areas. So it's a profoundly damaging, Dobbs is a profoundly damaging opinion, and it's like a bomb in the middle of our constitutional framework.
Ugh, okay, so on that note, I think we could say that the future is not bright in this next era in the fight for reproductive justice, but hopefully there will be a light at the end of the tunnel. And I certainly hope that we all go out there and pass Prop 1, and at least in California, for the time being, will be better protected. Thank you all for your insightful comments this evening. It was really great to hear from you as experts in the field. Queen's Bench really appreciates the fact that you joined us tonight, and we just wanted to thank all of you for being here. And Kimiko wanted me to mention that for the Queen's Bench people, our past president's dinner is next week, November 3rd. You can still register through Monday. We'd love to see any and all of you there. It's in San Francisco at Sen's Restaurant, I believe. And with that, I think we can close for the evening, and thank you all for coming. And again, we really appreciate it. Take care, everybody.
Thank you, everyone. Thank you, especially to our panelists.
Yes,
All right.
thanks, everybody. Bye-bye.
Bye-bye.
Thanks so much. This is great.
Thank you so much for inviting me to participate.
Oh, it was wonderful. Thank you, Anne.
Yeah.
Yes, this was fantastic, everybody. Well done. Thank you very much.
Yeah.
I hear
you,
Sharon. Yeah. Thanks, Sharon,
Hey.
for all your hard work.
Yeah, thanks,
Okay.
Sharon. Okay, we can all go all have dinner now.
All right. Good night, everybody.
Good night.
Bye-bye.
Bye-bye.